Seconds to go. Start. On the special leave petition being preferred, notice was issued on 18th July 2022. Stop. The only aspect, on which notice was issued on 18th July 2022, was on the plea of the learned counsel for the appellant that the present case would fall under Section 304 Part 1 of the IPC and note Section 302 of the IPC. Stop. The appellant had already undergone actual sentence of 12 years by then. Stop. Para. Arguments have been heard on the aforesaid aspect after grant of leave on 22nd August 2022. Stop. Para. Learned counsel for the appellant contended that both the appellant and the deceased were consuming liquor and started fighting under the influence of liquor. Stop. In this altercation, the appellant picked up a nagar wood and inflicted few injuries to his father, which resultantly caused death. Stop. There was no motivation and intention, which means that the essential ingredients of Section 300 of IPC were absent and the conviction under Section 302 of IPC was erroneous. Stop. Moreover, alcohol was also found in the stomach of the deceased. Stop. Para. It may be noticed that the learned counsel for the appellant sought to contend on the aspect of whether the conviction could be based on the last seen theory. Stop. However, that is not the aspect on which notice was issued. Stop. Para. Learned counsel for the respondent sought to initially contend that in case of the homicide committed within the privacy of a house, there is burden on the inmates to offer a cogent explanation for the crime committed. Stop. The testimonies of witnesses establish the crime. Stop. Once again, we have to say that is not an aspect, which is required to be examined by us in view of the limited notice issued. Stop. Para. On the issue of the nature of offence, learned counsel for the state relied upon the judgment in Suren Singh versus State of Punjab to make out a case under exception 4 of Section 300 of the IPC. Stop. Section 300 reads as under para. Except in the cases hereinafter accepted, culpable homicide is murder, if the act by which the death is caused is done with the intention of causing death, or if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or if the person committing the act knows that it is so eminently dangerous that it must, in all probability, cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. Stop. Para. Culpable homicide is not murder if it is committed without premeditation in a sudden fight in the heat of passion upon a sudden quarrel and without the offender having taken undue advantage or acted in a cruel or unusual manner. Stop. Para. It is immaterial in such cases which party offers the provocation or commits the first assault. Stop.